So this is actually the perfect talk to come after the talk we just heard. It's almost like you guys planned the program because some of the things that we just heard about are the things we hope to do in this project. And as you'll hear as I talk about it, it turns out we had quite a circuitous journey, and there was a whole other project that had to happen first. So I'm really happy to share this with you tonight. On behalf of myself and my wonderful co-author, Caitlin Phillip, who had an emergency come up and couldn't be here tonight, but we will of course both be happy to answer questions after this if there are any questions specifically for her kind of domain of work. So let's get into it. I'm going to start like a lot of lawyers like to start, and that's with a case. And that's because this is the case that motivated this project and this analysis. And that's the case of Flowers v. Mississippi. To orient you to these facts, so this is a case about an incident in 1996 where a Black man named Curtis Flowers allegedly murdered 4 people in Winona, Mississippi at a furniture store. So the 4 victims in this case, Bertha Tardy, Robert Golden, Derek Stewart, and Carmen Rigby, were all employees of the store, and all of them were white. The prosecutor in this case, Don Evans, was white as well. And to give you the context of the setting of Winona, Mississippi is approximately 53% Black or African American and 46% white. And here is one of the strangest procedural histories you will ever come across. So there was a first trial where Curtis Flowers was convicted, but this verdict was reversed by the Mississippi Supreme Court due to prosecutorial misconduct. In the second trial, Curtis Flowers was convicted, and it was reversed by the Mississippi Supreme Court due to prosecutorial misconduct, specifically discrimination in the jury selection process. In trial 3, Curtis Flowers was convicted. The conviction was reversed by the Mississippi Supreme Court due to prosecutorial misconduct, specifically discrimination in jury selection by the same prosecutor in all 3 trials. In trial 4 and trial 5, there were mistrials due to a hung jury. And in the 6th and final trial, Curtis Flowers was convicted. The conviction was upheld by the Mississippi Supreme Court, but it was reversed by the US Supreme Court for prosecutorial misconduct, specifically discrimination in jury selection, with the court opining that the trial court committed clear error in concluding that the state's preemptory strike of Black prospective juror Carolyn Wright was not motivated in substantial part by discriminatory intent. So this is the procedural history that inspired us to start this project. Because when you look at something like this, fun fact, this is actually the 2nd highest number of trials in a case in Mississippi ever for criminal trials. And there is no limit technically to how many trials you could have. This case ultimately ended with 6 because the prosecutors declined to go for round 7. But we were really interested in how this could possibly keep happening over and over again, and what the circumstances were in the courtroom surrounding these preemptory strikes of these very rare Black jurors in a town where half the town's population was Black. And we were looking around for what type of legal data could help us investigate this issue in sort of a more rhetorically nuanced way. And we settled on the concept of Batson Challenges. So the Batson Challenges are named after a case called Batson v. Kentucky. And the premise of Batson, and the thing to know, is that Batson Challenges or preemptory strikes do not remove biased jurors. Rather, they're an attempt to prevent lawyers from striking jurors on the basis of their race or gender. So this is to guard against what's happening in this Curtis Flowers case with prosecutor Don Evans. And Batson Challenges are often criticized by scholars and activists as insufficient, as poorly protected, and is wrongly shifting focus away from protecting the rights of the defendant to sort of putting very loose rules around the behavior of lawyers. So, and Batson Challenges are rarely empirically measured, and they're not so frequently brought. And we started thinking more about this and why a project like this would be so important. And because a lot of us here are not as familiar with the American legal system, perhaps, I wanted to give sort of an update on why in this particular context, the jury and the specific case of criminal jury trials is so important. So many legal systems have juries, of course, but there's an argument that the US legal system uniquely elevates the importance of juries as a proxy for ordinary Americans making significant legal decisions. So in this way, kind of social scientists argue that juries come to reflect elements of the dominant culture that then make their way into the courtroom and subsequently in the legal decisions that come out of the courtroom. And notably, juries do not sit on most criminal cases in the United States. It's a very small minority of cases that go to jury trial. But these cases are some of the cases people care the most about, some of the highest stakes cases, and the cases that go on to rhetorically define the system of criminal justice in the US. So we proposed a project based on that kind of elevated importance of juries and these sort of wild cases where the same types of peremptory strikes and discriminatory patterns were found in the case documents, and proposed to gather criminal transcripts from a number of jurisdictions so that we could leverage our expertise as data rhetoricians. My colleague, Caitlin Phillip, is a rhetorician. And we could then analyze these transcripts in a more sort of holistic way to not just determine the frequency of legal challenges and their outcomes, but also look at circumstances where such peremptory strikes could be made but aren't, and look at the rhetorical construction of racism in jury selection, right? Because it's unlikely that people are using the most obvious words to code some of these decisions, but there might be other kind of nuanced and textual patterns we could pull out from these transcripts. So you can see how this is almost a computational text analysis project, but here's what happened. In order for this to be feasible, 4 conditions have to exist. First, we need the ability to identify a universe of cases. We then need to get the transcripts. We then have to computationally or manually process the transcripts in whatever way. And then we have to make meaningful legal meaning of those transcripts. And as we embarked on this project, we became optimistic about actually the latter steps, our computational legal steps, but we were less optimistic about our ability to identify a universe of cases, and we're downright completely dead, stop cold on our ability to get the transcripts at the scale you would want to do this type of computational legal work. And here's why. Here's an example. Just by coincidence, we just saw an example, an AI example from Evanston, Illinois. This is Cook County, Illinois, in the same place. And Cook County is home to 26 in California, one of the busiest felony courtrooms in the United States. And the Administrative Office of Illinois Courts annual report states that 7% of defendants went to trial. But finding the actual number of trials is very difficult. And finding specific information on which cases went to trial is nigh impossible, unless you have sort of a background structure where you can pull PACER data, crosswalk it to UCCS data, which thankfully we were able to do. So we had some sort of tentative universe of the cases, and we thought, okay, maybe this will work. But here's the big problem. To get a single transcript, you need to first know who to get it from. Second, in Cook County, you need to provide a lot of information: the date of the hearing, the case name, the case number, the courtroom number, and the name of the judge. And if you need original transcripts, you will be paying $4 per page. And this is just to collect one transcript. And when we actually tried to do this in process, this is the web page you are greeted with for the Circuit Court of Cook County. It has nothing on it. And if you click those lovely buttons on this menu here that says transcript orders and rates, it goes to nowhere. And what you would have to do to even find information I showed you just there is back your way back out, find a cached page on Google, and pray that that's the same true information now. And if you manage to do this, you will pay somewhere between $200 and $400 US per transcript, but we don't know how much they are because we don't know how long they are. And this becomes a problem for our goal to do computational legal analysis because we confront the problem of scale. So every jurisdiction has their own separate process for pulling these transcripts, and there is no universal tool to obtain this information. And this is not so simple as saying, okay, let's look at federal level crime, where there are kind of more statutory limits on transcript prices and formal processes, because a lot of the action in criminal law is not at the federal level. It's at the state court level. And so we don't want to just pretend none of those things exist and only look at federal cases. Plus, we love a challenge in this conference, I think. So to get all of these transcripts then from the entire United States, we have to know who to ask and how to ask in every single county. We have to provide some type of information in every single county, and we have to pay something to someone to get something in every single county. And so our preliminary estimates on how to do kind of the baseline work on this is we think it'll take between $2 and $4 million of just the raw page copy requests to get the data we want. And so as you might expect, because of this difficulty, there's a limited universe of scholarship with primary documents being criminal court transcripts. There are some. I've plotted here a couple studies for you where the number of transcripts analyzed are around 104, 15, 43, and even this case with 104, the authors of the article had kind of specific unique connections to be able to obtain those transcripts. So this helps us define the scalability problem that prevents us from having system-wide knowledge about court processes that can only be revealed via this type of unstructured text, because the rhetoric and the peremptory strikes we're looking for aren't replicated in a lot of our kind of normal case documents. And so this is a problem not just because Kat and Caitlin are really sad they can't get data. This is a problem because there is a constitutionally protected right that the public has to access court proceedings and court records for criminal cases. And so I'll spare you kind of the legal diatribe of going through all these cases, but I wanted to plot for you here some of the landmark cases in this space, specifically the Richmond newspaper's case in 1980 and the Globe newspaper case shortly thereafter, which concretely and specifically say that the First Amendment gives the public the constitutional right of access to criminal trials. And this was transformed into not just being present at a criminal trial, but to the record themselves in this Associated Press versus District Court case in 1983. So there's more going on here than just saying the public should have access to data about the public system of government. There's also kind of the legal and constitutionally protected imperative that this data be public. And so a concept we very quickly encountered in this work is the difference between de jure and de facto public data, right? So information can be de jure public, but practically speaking, almost impossible to maintain. So these court transcripts are legally public, but practically speaking, the veracity and practicality of that term is quite a bit more debatable. And we wanted to wrap this kind of discussion in a kind of a useful theory context for understanding how individuals motivate and enforce their rights. So we think the managerialized rights framework is really useful here. This is often used in employment law, in hate crime litigation, and in Title IX work. But the way you can think about it is it's characterized by two things. First, it's characterized by a group of people whose rights have been violated, but who are not currently vindicating those rights. And then second, the rights themselves are not self-enforcing and are enforced differently depending on the parties and their respective agency. So to sum that up, managerialized rights functionally shift the burden for protection to the persons who are potentially exploited against the institution that theoretically has the burden of protecting them, right? So in this case, the onus is put on the public to understand, enact, and financially sponsor public record requests that they're theoretically constitutionally entitled to. So we argue that this is important, not just because the public should get to look at it because it's constitutionally protected, but also because it reifies and exacerbates inequity. And this is done basically by a court-endorsed fee structure where public court records are practically speaking inaccessible to most people. And we see this not just with transcripts, but also with some of the other sources I'm sure we're using throughout this conference, like PACER data, that even for getting partial coverage of a year of PACER data, you can spend $100,000. And the court has sort of a public-facing solution to this problem where they argue that electronic records can be viewed in the clerk of court's office for free if they have not been destroyed, transferred to an archive, and if you do not want copies of them to take home. So those are still like functional limits on the amount of accessibility you actually have. And we argue that at scale, this functionally shields the court from liability and prevents folks like all the people in this room virtually and physically from doing the types of audits and system analysis to disentangle different types of bias and inequity. So before we could do our really cool project we wanted to do about Batson Challenges.
Now
we decided we would do an audit of availability of court transcripts and court record information at the county level. So we decided to go at the county level again to avoid kind of falsely aggregating to the state level, but we also included census areas, districts, and boroughs where important. So this was 3,244 valid areas. And we went ahead and we coded them manually, which took a minute. And it's a little bit funny here at a computational law conference to be like, let's do 3,244 examples of manual coding. But we did this because we wanted to kind of approximate the experience of a regular person trying to find a record. So we knew the coding team, which was myself, my co-author, who both went to law school, and a very talented law student. We know that these record policies are under the purview of the county clerk, but a regular person might not know that. So we walked it back out to a general search engine, and we looked for first any information we could find. We then looked for any price information about transcripts, any information about the types of information you need to process the request, and then any logistical requirements to obtain an output. And here are four sort of themes that typify what we found. So first, you'll be unsurprised to hear there was a few types of missingness. First, a lot of counties just did not have a data policy that was findable online, especially smaller and more rural counties. And a lot of data policies just generally were written in such a way to kind of not include transcripts. A lot of them were things like getting the title to your property. And there was no sort of imagining that anybody would be coming looking for criminal transcripts. And there was also sort of obfuscations of process that we argue are functionally equivocable to missingness, right? Like things that are like, call this number, like in Benton County, Arkansas, but the phone just rings, nobody answers it. And it's not actually information about court records, just kind of another pathway, another rabbit hole to follow in pursuit of this information. The second theme I want to share with you today is what I'm calling varied procedure for a legally identical process. So theoretically, right, you are trying to obtain the same thing from county courts that are at the same level, and you should probably be able to do this about the same way in each county, but that is not the case. So even at the most fundamental level, counties had different ways of dealing with record requests. In some of them, the county clerk handles the request, which we would view as kind of the more like correct modus operandi. In other cases, the requester must contact a court reporter directly. And in other cases, there's a completely different third party that handles the request. And this can create compounded burdens to access for the public because even the processes of doing the same thing aren't the same. And here's an example from a county in Michigan where they required that someone who wants a transcript must contact the specific clerk who was assigned to the relevant judge who heard the case. And were you not in the courtroom, were you not a party to that case or a legal representative on that case, I don't know how you would know that. So third, this one should be unsurprising, but we found a theme around financial burdens and outdated processes. So the price per page usually ranged between 25 cents and $1, meaning that our target jurisdiction to start in Cook County was one of the worst. But these weren't the only things you have to pay for. There are research fees, shipping and handling fees, and service fees. In particular, the research fees were particularly insidious. In this example from Pima County, Arizona, the requester of a transcript is assessed a $30 fee for every name the clerk has to search. And the example they gave is that if you gave forth a name like Michael Smith, and there were 6 of them, and the court reporter had to look at all 6, you would get charged $30 for each of them. So the less information you have, the more potentially you could be on the hook for paying. And it will be unsurprising probably for us to hear that a lot of these processes are outdated or inefficient. In La Paz County, Arizona, they require requesters to send a self-addressed and stamped envelope that the document will be mailed back in. Now, this is surely not optimized to possibly mail you a criminal transcript, a criminal trial transcript, unless they make a lot stronger envelopes than I think that they do. So our third out of 4 themes is this idea of what knowledge you need to actually initiate a search for these public records. So this is highly variable. In some counties, all you needed was a case number and party name. But in other counties, you might need the specific date, the judge's name, and in one county, the number of pages in the document, which I don't know how any reasonable person would be able to estimate how many pages are in a criminal trial transcript, even if you sat there in court and listened to the trial. But there are some reasons for optimism here. There are indications in some of these county policies that you can actually motivate the search with significantly less information. These 2 counties required only a description of the case or the defendant's last name and an estimated date, meaning that at least in some counties, there is theoretically capacity to assist the public in identifying records with less information. And so in conclusion here, what our audit demonstrates is a systemic process of distancing governmental responsibility and managerializing public access to public records. That is, there's a lot of hoops for the public to jump through, and these hoops are variable. And so even being able to do it in one county doesn't mean you're going to replicate your success somewhere else. And this ultimately is an elevated burden placed upon individuals who are attempting to engage their constitutionally protected rights. So this affects not only researchers who are trying to add knowledge and policymakers looking to evaluate process, but is also offensive to the very notion of public access to public documents. So as we encountered this problem, we were percolating on solutions and thinking particularly about what we as a computational legal studies community can do about problems like this. And we think that computational legal analysis has a unique ability to pattern and analyze bias, both substantively in these records, but also to quantify gaps in transparencies and in access in ways that are actionable. And this, of course, fits in with a lot of the tenets we're observing in this conference about data sharing, open access, open data. Ultimately, the lawyer in us also argues that there needs to be an overhaul to the current system where accessibility is part of governmental infrastructure, i.e. that Congress needs to bear the financial burden of making public records accessible. So there are some limitations, right, to the audit that we did. One, that the 3 people who did the audit are more legally knowledgeable than the general public. And we also coded publicly available information about the process, not the reality of what would actually happen if you tried to engage the process in each county. So we are working on those problems right now. So a big important thing for us in this deliverable is to contact counties who have insufficient processes and place the audit not just in a relevant traditional academic output form, but also in a practitioner relevant location, so that the magnitude of the problem can be seen by people who solve these types of problems. And we also want to more concretely quantify the gap between expert knowledge and layperson knowledge. We were thinking, I'd be interested if anyone has any opinions on this, but we were thinking of maybe doing some kind of prolific surveys and having lay people try to replicate the information finding that we did in the audit and see how close the general public can come to the kind of final version that we have. And we also have begun the project of piloting various counties and states and the actual transcript gathering itself, not just to do our substantive findings, but also to extend the current audit to reveal any differences in what the policy is claimed to be on the website and what policy we actually followed to get the documents that we wanted. So with that, I will yield my time to any questions. Thank you so much, everyone, for hanging out, especially because I know it's 10 p.m. right now in Georgia, and I think it could be that late other places too. But thanks, everybody. Yeah, there's a question from Thorne.
All right. So the very interesting, disconcerting what you discovered. So it seems to me that this problem could be solved if courts were doing, say, automated transcription, because then you'd have audio recordings and speech recognition, and so you'd have an electronic transcript. Do you have any sense of how extensively that technology has worked its way into the court reporter system these days? Yes or no? Yeah. Minimally? What?
Yes. So the first half of my answer is an optimistic one, where I'm like, there are actually a surprising number of courts who are doing digital recording, including a lot of courts you think wouldn't be because they're too small. But there actually are a lot of courts using it. However, there are substantially fewer courts who are willing to transform the digital record into a record they're willing to give to the public, and they still charge you for the service of producing the record. And I think so. I'm working on this with some colleagues from the Scales OKN group, thinking about integrated justice systems and how there can be more of what you're talking about, sort of automated processes to produce the transparent record, so that it's less ad hoc, piecemeal. Pay the clerk $30 to do this one thing. Pay the clerk $30 and again, and produce that stable knowledge base more efficiently. And I think that that is a very promising pipeline if we convince the courts to do it.
Thanks.
Yeah, thanks, Jason, in the chat. I appreciate that. And if anyone has any other questions, definitely feel free to send us a message, and we are going to make our audit and any transcripts that we pull public. So if anyone else has cool projects that you want to do with large text corpuses, keep an eye out for it, because as soon as we got them, we're going to share them.